Hi, it's Mike DelSignore, Massachusetts OUI Lawyer. In today's video, I want to talk about what happens if you were found asleep at the wheel and were charged with OUI. So I've had a lot of these cases over the years, and there's some different variations of this type of case. The best situation is you're pulled over, you're in a safe area, and you're sleeping. You're either in a restaurant parking lot. I've had cases like that. Had one in Attleboro where a client was found not guilty. Had one in Peabody. I feel like that's a great case because it shows that you knew enough not to drive. You might have been tired. The field sobriety tests, there are other ways to explain those. Someone may not perform well because they're tired. Medical issues. Sometimes the officers rush through the instructions. So when there's no bad driving, it puts the case almost entirely on the field sobriety test. So I usually can neutralize those very well. Field sobriety tests, I think, usually benefit my client more than the government because I know the office is training on these tests. I know what they're looking for, what they're supposed to find. And in almost all cases, I can find some flaws with the tests. If you didn't fall, you didn't do it. If there's no dramatic error, these tests are usually not a major problem at trial, and they can be neutralized. I don't think juries or judges put as much weight on these tests as people think, and the cross-examination on field sobriety tests is generally very effective. If there's a breath test, we may have to get that excluded from evidence, but I've even won cases where I had a client who, and this is the second variation of a sleeping behind the wheel case. This client was sleeping in the breakdown lane. There was a breathalyzer. It came in evidence. She was still found not guilty. I've had and that was in Lynn District Court. Had another one in Lawrence, sleeping in the breakdown lane, also not guilty. So that's a little more difficult because if you're in the breakdown lane, it suggests that, well, obviously you're not in a safe place, but I still have the argument that you knew enough to pull over, you were tired. And I think juries like to give people credit for getting off the road. So that's the key point. And I think that's why I've had success. I even had one in Rentham. So I've had a lot of these sleeping behind the wheel cases. The worst, so there's you're sleeping in a parking lot. That's the best case. Second best, you're sleeping on the side of the road. You're not in traffic. And again, we can emphasize that you recognize you were tired, you pulled over. That's what we want people to do. We don't want people to continue to drive. It shows good mental awareness, alertness, that you got off the road. And one of the things a jury is instructed when they assess whether someone's under the influences is their alertness, judgment impacted by alcohol. So when we can get to the point where we can say, well, maybe it wasn't, maybe it was fatigue, maybe it was alcohol, that's reasonable doubt. We don't need to prove you innocent. We don't need to refute every point of the government. We just need to put as much doubt there or raise as many questions where we can say it could be this, maybe. Because the standard at trial is proof to an abiding conviction to a near moral certitude. And the jury's instructed that it's not enough to even have a strong probability. So if we can get to the point where we can say, yeah, you don't even have to think it's 50-50. As long as there's some chance that this person might have just been tired, that should be a not guilty. And the other technique I use is, to the extent I can, most of my clients have great backgrounds. They're hardworking people. They're raising kids, families, running businesses. If I can get some of that evidence in, and usually I can through the officer. Generally in booking, you'll tell the officer a little bit about yourself. So then I can ask the officer in cross-examination about that, and most officers will agree. Often it could be in a booking video as well, which allows me to give them a little background about you. There's another way to do that. You could testify, of course, but then that exposes you to cross-examination, and in some cases that may hurt the case more than help it. Certainly, there's another strategy in these cases where you testify and say, hey, I knew I was tired, I just pulled over. In the driving cases the sleeping behind the wheel cases I've had, I can't say I remember calling anyone to testify in that type of case, but I certainly would and consider it in the right case. I have called clients in other cases to testify, and it's resulted in many not guilties. Most of my clients, if I put them on the stand, generally they'll do well. I don't put a ton of people on the stand or recommend that, but if I recommend to you to testify, chances are I'm very confident you'll do very well as a witness. It's not as scary as people think testifying. People picture that there's going to be a lot of people in the courtroom. The DAs generally don't do a great job cross-examining. Usually the cross-examination that I'll do in the office will be more vigorous than what you'll even get in court. So the final type of sleeping behind the wheel cases is you're in the road, the car's running. That's problematic because that suggests that you just weren't aware of your surroundings. A case like that may be difficult to fight. We look into everything, but that might be a case where we would consider resolving it. So that's probably the worst type of case where you're sleeping in the road and people waking you up and the car's still running. But these are generally very good cases to fight, and I've had a lot of success because, and that's the key point, you knew enough to pull over. Sleeping behind the wheel certainly is evidence that maybe you shouldn't been behind the wheel, and something's affecting your driving. They got to prove alcohol is the cause. So if you have a case where you're found sleeping behind the wheel, consider fighting it. Give me a call. I can give you my experience on these types of cases. In some cases, you might even get an immediate threat suspension on your license, so watch out for that. My passion is helping people make the best decisions for themselves when charged with OUI. Call, text anytime, 781-686-5924. My name is Mike DelSignore. I've represented people all over Massachusetts for the last 20 years, helping them be found not guilty, avoid OUI convictions, and I can help you. Thank you.